Morning.
Good morning, Your Honor.
You may proceed.
May it please the court. My name is Bob Stoller. I'm with the Stoller Russell Keener Verona law firm here in Tampa. And our firm has the pleasure of representing the appellant in this case, Sheriff Nocco, who's been sued in his official capacity. And that's the equivalent, of course, of a claim against the Pasco County Sheriff's Office. This is an appeal which arose from a denial of the sheriff's motion for summary judgment. And the denial was based on a finding that there was no sovereign immunity arising from the accident giving rise to the claim. And the facts of that accident are pretty much undisputed, Your Honors. What happened was the arrestee, or the detainee in this case, was detained pursuant to the Baker Act. Mr. Brewster had voiced suicidal ideation. Deputy Madison responded. And ultimately, the decision was made that he should be taken to a psychiatric facility under the Baker Act. Mr. Brewster was handcuffed and placed in the rear seat of the deputy's cruiser. And during transport to the psychiatric facility or to the hospital, a very strange and unforeseeable thing happened. A deer ran out of the woods and struck the side of the vehicle.
Depending where you are in the county, it's not that out of
Yes,
order.
And I would love to argue foreseeability here before this court.
Right.
I am not. That's not an issue before the court, but it's a fact of the case that we need to discuss. And maybe an issue down the road. The video of the incident from the dash cam is actually in the record, and I think it's exhibit 1 or in the appendix, I should say. And we can see it's timestamped 26 minutes and 53 seconds into the video when we see on the video, the deputy is driving, the detainees in the back seat, without a seatbelt, and there's a slight shake in the camera. And that's, we know, is when the deer hit the side of the road. The deputy pulled over and gets out. When the deer hit the side of the vehicle, the airbags deployed and the plaintiff suffered injuries. And he subsequently brought suit against the sheriff's office. And the allegation against the sheriff's office is that the deputy was negligent for failing to secure the detainee with a seatbelt. And that's the allegation. Importantly, there's no allegations of negligent driving on the part of the deputy. Nor could there be, quite frankly. He was just driving along and the deer came out of the woods. So the issue will be, Your Honors, whether or not the failure to secure the detainee with a seatbelt is actionable. Starting out, of course, with the duty. For the purposes of our argument today, we acknowledge a duty. Of course, I read the Pownell case, which was from last March, when this court held that sovereign immunity barred a claim against the Pinellas sheriff for the failure to provide a vehicle with seatbelts. That was deemed to be a discretionary function. The argument we're making in this case, we'll get into that in a few moments.
The discretionary function there seems, if I recall correctly, was basically determined to be a policy consideration by the office to not have seatbelts in school buses across the board. So how is that similar to a situation where the sheriff's office says you can strap somebody in or not as you determine best under the circumstances? I mean, I understand the argument, well, that's a discretionary determination by the officer, but that doesn't seem to be a planning determination along the lines of what happened in the school bus case.
Yes, Your Honor. We need to go quickly to the commercial carrier 4 factors, which the Supreme Court directs us to look at in determining whether a particular act or omission is operational and actionable, or whether it's discretionary and barred by sovereign immunity.
But let's, and this is, I think, well argued in the briefs. Is there a difference between discretion on the macro level of a school board or a sheriff's office versus the discretion in the field of an officer as to whether to do certain things or not do certain things?
I don't believe so, Your Honor.
So if an officer, well, let me go back. If a department says you should not engage in high-speed chases unless certain things, and an officer decides to engage in a high-speed chase, loses control, runs into a house and kills somebody in the house. Based on your argument, that's a discretionary call for the officer that would be subject to sovereign immunity.
It would depend, Your Honor. I could jump in and mean interrupt, of course.
No.
It would depend on the factual circumstance and the policy at issue. I'll take the court to Keisner versus Cole, 1989. It's a traffic stop, the side of the road. The officer orders the plaintiff to stop his vehicle. I think it was in a turn lane, but it was in a through lane of traffic. Arguably, the officer detained that plaintiff, Mr. Keisner, by ordering him to stop his vehicle in the road, creating the zone of risk. And that's what happened in that particular circumstance. And the plaintiff in that case alleged, Your Honor, to answer your question, that the deputy failed to follow proper police procedure. Not the case here. Deputy Maxon followed proper police procedure.
See, and this is where I think the whole, it is a policy function and to the exclusion of possibly being any operational component to it, if and only if there is a didactic policy that prescribes the exact conduct that we're talking about. That can't be the distinction.
No, Your Honor, I think that's cutting the onion a little bit too thin.
Well, but I think that's kind of where your argument's landing. I mean, put it this way, when you've got the corporate representative testifying, hey, if he had asked to be seatbelted in, we would have put a seatbelt on him. Doesn't that just right there take this out of the policy-making realm, which is what commercial carriers really trying to drill down to, which is this a policy of the governmental entity, or is it just day in, day out operational kind of thing? And it just seems to me that what we're talking about here, when under these facts, where you've got seatbelts, where the corporate representative says, yeah, if he wanted a seatbelt on and asked for it, we'd have put it on. The officer's discretion or decision is a day-to-day operational kind of decision, regardless of, whether, the fact that the policy doesn't specifically address this exact scenario.
Well, it provides, of course, discretion to the officer, and we have to remember why the policy provides that discretion. On its face, the purpose of the policy is for safety, both the balancing of the safety of the detainee as well as officer safety. And looking at Plonal, and then looking at the Louisiana case, Vincent, which is cited, where the court found that sovereign immunity barred a claim under the Federal Tort Claims Act, which our sovereign immunity statute is modeled after. And Vincent, again, not binding by any respect, but it's a case where there was a car accident and an inmate, federal inmate, was not secured with a seatbelt. And the court in Vincent held that that was a discretionary function on the part of the officer, whether or not to, because of this policy consideration of officer safety. And I wanted to quote from Kaiser, just to address Your Honor's last point.
Yes.
Because we haven't talked about the separation of powers, and that's the real reason behind sovereign.
I really want to get there because that's a
Yes.
very important consideration.
And when Your Honor asked that question about operational versus discretion, I immediately went to the court's decision in Kaiser, and here's what we have. I'm sorry, in commercial, Kaiser, quoting commercial carrier, which is the 4-prong test. And I'm looking at, again, the Kaiser opinion from 1989. And in discussing the 4-part test, the court stated the following. First, did the act of the officers in this instance involve a basic governmental policy, program, or objective? In this instance, it did not. Not true with us. In the Brewster case, the basic policy objective was this very important decision of whether or not an arresting officer should restrain the detainee with a seatbelt. And there's that balancing. Is it because of officer safety? Naturally, because, and again, it's quoted in Plonal and Vincent, when an officer has to secure an inmate in a vehicle, he or she necessarily, until technology changes, has to lean in and get very, very close to that inmate.
That brings into play, as you said earlier, all the circumstances involved in this situation. And so isn't that better suited for a determination of a basic negligence action as opposed to a broad sovereign immunity determination?
It is not, Judge, simply because of that discretion and the play of officer safety, and then back into the separation of powers. Here's the important quote from Kaiser. I read the first element as to whether or not it's the act or omission involves a basic governmental policy. Well, here it does. This is transport of detainee. The second quote is the act essential to the realization of the policy? Well, it is, because the inmate either has to be restrained with a seatbelt under the policy for transport or not. But the officer has that discretion to make the call. The policy does not require it. The officer followed the policy. And I stress that for the third point, and I'm sorry for the roundabout.
But one part of that that's a little troubling is the testimony that, well, if he would have asked for it, he would have seatbelted in. How is that part of the officer exercising any discretion?
He could still, let's say, unfortunately, the inmates sometimes, detainees sometimes can be unpredictable, can be combative.
No, we all understand.
And just,
But if you're saying in this case, the officer was deferring to the wishes or would have deferred to the wishes of the passenger, How is that a discretionary is deferring to the passenger, that a discretionary call within this broader policy?
Well, with all due respect to the major who gave that testimony, that is not the factor determining whether sovereign immunity bars the claim. An individual from the agency can't say if he would have asked, we would have given it, and thus sovereign immunity doesn't bar the claim. The testimony of that individual, that's not the analysis. And even if the detainee does ask to be restrained, the officer still has the discretion not to because of officer safety.
So let me give one other hypothetical that I thought about.
Yes.
Officer engages in a vehicle chase, decides he's going to be John Wayne and he's going to shoot out the tires to stop the vehicle. He is a really bad shot, misses and hits some bystanders. That would be a discretionary act that is subject to sovereign immunity.
I don't believe so, Your Honor, because I don't think there's a policy or procedure in the court's hypothetical that would give the officer that discretion to shoot wildly.
And here's what's troubling me. Your entire argument revolves around, well, if they enact a policy, it is hands-off policy, and whatever they put is sovereign immunity, you can't touch it. I mean, in theory, the sheriff's office could enact a policy that says, out of concern for the officer's safety and the public safety, all detainees taken in under the Baker Act shall be proactively tased. Right? That's assume that's policy. And then suppose someone is hurt or killed in being tased and taken in pursuant to the Baker Act. You would not argue, or would you? Hey, separation of powers, sovereign immunity. They enacted a policy. This is a policy they carefully balanced the public's interest versus officer safety. They have a policy in place, and therefore any lawsuit is subject to sovereign immunity on the policy that they've.
I think in the hypothetical, that would be an absurd result. If the policy on its face appears to be allowing for it.
That's why I made it, and I'm trying to tie it into the argument that I'm hearing, which I keep hearing again and again. Well, there's a policy. There's a policy.
Yes, Your Honor, and I'm sorry. The third prong,
Sure.
Because this is a quote that addresses those questions. And again, quoting from Kaiser. Third, did the act require basic policy evaluation or expertise? In this instance, it did not. For the reasons stated earlier, the act in this instance at best involves secondary judgment. Strike that. This is the important language, Your Honor.
Wait, before you go too far,
Yes.
isn't a secondary judgment what an officer does in the field?
It is, and it's a matter
I
of
just want to make
semantics.
sure we're not missing that part of it.
When an officer rear ends somebody, God forbid, that's a discretionary thing. They have the discretion to hit the brakes, at least arguably. So when we talk about discretion, it's not like we commonly use in ordinary conversation. We have to go to the policy consideration. And that brings me to the quote, and I'm sorry for taking so long. Here's what the Supreme Court said on its third prong in Kaiser, quoting the commercial. Were we to establish a rule preventing officers from ordering motorists to the roadside, then we improperly would be entangling ourselves in matters involving basic policy evaluation or planning. And that is the separation of powers argument, Your Honor. In response to Judge Lucas's inquiry about the hypothetical of, let's say, an unconstitutional policy, I think the argument could still be made, obviously respectfully. It's not the role of the court to be deciding law enforcement policies and procedures.
Okay, but here's the thing. This all comes about in a backdrop of a Florida statute that expressly waives sovereign immunity on negligence claims up to a certain cap. So we have we have this, yes, there is a separation of powers argument, but at the end of the day, what we're talking about is a common law doctrine of sovereign immunity that has been legislatively waived to a limited degree. It seems like the legislature has made known what their will is on this, which is that we're okay with negligence claims. The courts have then come back with what we have in place now that we have to work with, but there is a statute here that we should be looking at.
There is, Judge, but 8 months ago, this court deemed that a claim against the Pinellas Sheriff was barred by sovereign immunity when they provide a vehicle with no seatbelts for transport of people who are in handcuffs. So yes, years ago, our legislature passed a law, but it's a limited waiver, Your Honor. It has to be case by case.
Yep.
And here, what is unique about the Brewster case is this policy that on its face provides that discretion. And undisputed facts, the deputy did not violate it.
I know, and I understand why you keep going to the Pownell
Phonologically, QW, any other.
case, I mean, I get it, because there certainly is an allure to tying that to what we, seatbelt, sovereign immunity, law enforcement taking somebody in, I get it, but there's a punchline in that decision where the court says the decision of a law enforcement agency to provide seatbelts in vehicles used to transport prisoners or detainees clearly involves important policy considerations regarding the safety of prisoners and detainees, law enforcement, corrections staff, and
That's right.
the public. But that seems to be limited to that decision, whether or not you are going to have vehicles with this function, not whether you're going to use the items that are available, the tools and resources that the county gives you.
Literally the same page that Your Honor just quoted from the opinion. This court talks about the Vinzant case, which they said the following. In Vinzant versus the United States, the Fifth Circuit held the decision of U.S. Marshals to secure prisoners with seatbelts was based on a policy choice, striking the balance between the safety of the prisoner during transport and the safety of marshals, which might be imperiled if the marshals had to get close enough to prisoners to buckle and unbuckle their seatbelts. So if this honorable court is to affirm this ruling from the trial court, then necessarily every officer no longer has that discretion, because
Or the sheriff's office has to provide a more definitive policy.
that could be the option as well. But
And you have about 3 minutes left. You didn't ask to reserve. Do you want to reserve any time?
I can, I'll take those 3 minutes. Thank you so much. Appreciate it.
Court. My name is Robert Force. I'm here on behalf of claimants for the appellee, Joseph Brewster, my partner, and Humphrey. I'll be very brief with my argument on what was
Turn the microphone a little closer.
And I want to stop you before you get started, because the last exchange involved, well, if we agree with your position, wouldn't it effectively take the discretion away from officers, and they would have to put on a seatbelt in every instance? Is that not correct?
That's not correct.
Okay, how do you respond to that?
Well, we respond to it because we're not the position in this case, and it's very fact specific what happened. Mr. Brewster, was not being combative. We're not saying it has to be applied in all situations, but we had an expert opinion, which we didn't get a chance to do that position yet, because of the status of the case. But in that particular case, what we're alleging is that under those facts, it should have been reasonable to at least offer to place a seatbelt on Mr. Brewster. They never gave him the option. They didn't make any attempt to do it. He was not being combative. If the court, I'm not sure if you had an opportunity to read the body cam, but Mr. Brewster was given an opportunity to smoke a cigarette, had a conversation, spoke with the deputy. The deputy said, "Are you ready to go?" So yes, turns around, gets in. He said, "Yeah, 300 discs in my back."
How is that a cigarette?
He wasn't handcuffed yet. They were having a discussion, let him smoke cigarettes. It's not on a body camera. So what happens in that case, what we're saying is under those those facts, and Major Sanborn basically admitted that there's times when he's put handcuffs on people who are not being combative. And it relies on the officer's discretion, not in the discretionary operational function dichotomy, but within the true definition of discretion, officer discretion here. So we're not saying that he should have a policy that you have to place a seatbelt. We're saying under these circumstances, he used poor judgment in not even offering to place a seatbelt on Mr. Brewster. Again, we understand we may lose that issue at trial, but that's a discretionary, that's an operational level function. And I mean, just to simplify, the one case has not been discussed yet. Sanderson v. Bowden, and I believe it's page 537 of the opinion, states almost 4 years after our decision in Everton, we issued our opinion in Kaysner, which held that acts by law enforcement officers in respect to persons whom they detained, other than whether to arrest or detain the person, were operational acts not protected by sovereign immunity, in reaching the conclusion we stated, and so on and so forth. But the courts ruled that they applied this commercial carrier test to people who have already been detained. And once they're detained, they're owed a common law duty of care, and it's an operational fact, or it's an operational act, and that's simply what we're alleging. And I think the court properly pointed out the distinction in the Paul case, in that there was a policy not to provide any seatbelts in the back of prisoner transport units. That is a policy that they have in place. We're not here to question whether or not there should have been seatbelts in the back of the car or that particular policy, but they state, and it's not disputed, that there's a policy that it's okay to put a seatbelt on a prisoner under certain facts. we're stating simply that he made the wrong decision in not applying the seatbelt or even offering to place a seatbelt on Mr. Brewster. So with that, your honors, I'm sorry, I would like to address the Van Zandt issue, which has not been addressed yet, which is the federal court case. In analyzing that and reading the Federal Tort Claims Act, they almost define discretion in the way that Mr. Stoller wants to present the definition of discretion, which is an officer's decision in carrying out a policy. So I think it would be wrong to even consider the Federal Tort Claims Act case, the Van Zandt case, because of how it's defined in the Federal Tort Claims Act is not how it's defined in Florida. So in closing, I would just reiterate that I believe it's an operational fact, or it's an operational act as defined in the Henderson v. Bowden case.
Very good. Thank you very much. Mr. Stoller, you have your 3 minutes.
Thank you, Your Honor. Very quickly. May it please the court. If I heard counsel correctly, I think the argument is that the plaintiff, or the arrestee rather, in this circumstance, should be the one to decide whether or not they should be seatbelted, and that would be an absurd result. We can never take away the discretion of the arresting officer and leave it in the hands of the arrestee to decide whether or not.
Yeah, I mean, I just can't let this part of it go. If the policy is that the officer has to make determinations in the field based on all the circumstances, that almost seems to me to leave open the door for a possible claim of negligence when the officer makes a bad call. It is not a planning function for the officer to make a decision in the field like that.
Not a planning function, Judge, but the discretionary analysis under the 4 prongs of commercial carrier, it necessarily compels a conclusion that it is discretionary and sovereign immunity has to fund the claim. Because if the legislature, Judge Lucas asked about the legislature and their intent with what the defense calls, of course, a very limited waiver of sovereign immunity. But if the legislature wanted adults in the back seats of vehicles to wear seatbelts, they would have included it in the law. That's not the law. If the sheriff's office and other agencies wanted arrestees always to be seatbelted, that would be in the policies and procedures. I keep going back.
So the policy gets to define, the enactment of a policy gets to define whether or not they are immune from tort liability.
Not immune, Your Honor, but the policy gives the discretion to the officer based on their experience and expertise. And arising from that discretion necessarily flows the immunity because of separation of powers. I heard loud and clear Judge Silverman saying, what if we say, maybe it was in a hypothetical, that the sheriff's policy is per se unconstitutional? We have to remember to go back to the allegations in this case. There is not a request from the plaintiff in this case for the court to rule this policy is inappropriate or et cetera. This is just a simple negligence claim. And the policy obviously is longstanding and still in effect. Your Honor, I quoted a case, and I heard loud and clear the argument before me about supplemental authority, so I want to obviously be transparent. On page 69 of the appendix, the then defendant now did a notice of supplemental authority to the trial. It's in the record, and it cited a case called Coates, C-O-A-T-E-S, which is a non-published opinion from the Northern District, which follows Van Zandt. And I would like to quote that, and I certainly, it should have been in our brief, at least referenced, it was not, but it's in the record because it was provided to the board for. And I want to leave Your Honors.
So an unpublished U.S. District Court decision. All right, let's hear it.
Yes, sure. When you put it that way. For the record, the case is called Coates versus United States, and it's Westlaw citation 2020 WL 644-0204. And this is on page 4 of the opinion. And for the record, it's page 73 of the appendix. And the Northern District judge, Judge Williams, said the following. This arose from this very issue. It was the failure to secure a federal inmate. So federal court.
Just so you're Stoller, you're at the end of your time, so wrap this.
Yes,
issue
Judge.
up.
Plaintiff claims U.S. is liable for failing to use a seatbelt to secure him during transport. This conduct falls within the Federal Court Claims discretionary function exception. Therefore, sovereign immunity waiver does not apply. And here's the last 2 sentences, Judge. The decision not to secure inmates with safety belts during transport is a classic example of the type of policy choice that is shielded by discretionary function exception to the Federal Court Claims Act. The failure to secure an inmate with a seatbelt involves an element of judgment or choice because there is no statute, regulation, or policy requiring the U.S. to restrain prisoners with seatbelts during transport. And the same analysis applies here. Thank you so much, Your Honor.
Very good. Thank you very much. Thank you both. The next case is Fernandez versus Manzo.